before you start writing, figure out one, what's the purpose? Well, for this PT, the purpose was to write a letter explaining why W will not submit to arbitration. T, what's the tone? It's a formal letter, persuasive, written to the opposing counsel, so legally trained. You don't have to explain some of those legal terms. C, the content you're supposed to include is a short intro, short conclusion. You don't need a statement of facts. And your organization for this piece would have come from the Tuscany case or the opposing counsel's arguments, which was the letter they wrote to us. Format is standard letter formatting, and we don't have any samples of how to write this, except for the opposing counsel's letter, which you can kind of model it off of. Before you enter a PT, I always think you need to stop and think about these 1, 2, 3, 4, 6 things, and then you can start writing just to make sure you're on the right track. When you actually start writing this PT, again, we're just reviewing it. We're not talking as much about the phase 1, which is the process of extracting everything. We're talking about what you should have done and then what you do after you've completed a PT. In your introduction section, you would write, who are you? Well, you know, W and A sued SecureTrade, and you're the attorney writing on behalf of W, even though you represent Western and Assurance. Now, why are you writing? You're writing to tell them you will not voluntarily submit the fraud claim to arbitration, and you want to explain why the court will deny SecureTrade's motion to compel. And then finally, I usually say in the introduction, you have a quick summary, which is, oh, this is the roadmap of what I'm going to discuss. They were different contracts, we were not a signatory, and there's no direct benefit as alleged. And usually for an introduction in any PT, you would answer these 3 questions. Who are you? Why are you writing? And then do a quick roadmap. So it ranges from 3 to 4 sentences at the most, just so you have a pretty formal piece. Any questions at this point before we get into the nitty-gritty of the PT itself? All right, so the first section that we would have talked about is W is not a signatory to the BAA. And I'm using abbreviations because they're really long brokerage agreement, but this is the brokerage agreement that SecureTrade entered with Assurance. And SecureTrade's argument is, well, the Columbia Arbitration Act reflects a strong policy in favor of compelling arbitration. So they're saying because we have this policy, W, even though you're not a signatory to that agreement, you're going to be forced to go to arbitration anyways. And when you do a PT, remember, you want to split up the rules and the analysis just like you do an essay, like Iraq. In your argument, you're going to state, well, rule, a party cannot be compelled to arbitrate any dispute that he or she has not agreed to arbitrate. This comes from contract law. And in your analysis section, you now state what facts are relevant, and then you explain them. I've put the relevant facts that you should have got from the fact file in purple, and then the explanation of those facts or the inference/analysis in red. So you can see the 2 different things that you would have got separate points for. So the insurance policy has no arbitration clause. That was between Western and SecureTrade. The brokerage and administration agreement did have an arbitration clause, but that was between Assurance and SecureTrade. We now need to explain these facts, right? We can't just state these facts and assume that the reader or the judge or the person reading our letter understands what that means. We want to spell it out for them. Essentially, it's 2 different contracts, right? That's our inference, our explanation. There's a facts in purple, inference and explanation in red. Usually, if you were dealing with an essay, this would be enough. You wouldn't have to do a case comparison, right? You just say, here are the facts, here's the explanation based on the rule. But when you do a PT, you have to add a case comparison. And here we would compare it to the Tuscany case. And the facts in the Tuscany case was a non-signatory was compelling a signatory to a contract with an arbitration clause. We need to explain why ours is different or the same. And here we're going to say it's different than the Tuscany case because W is not a signatory, right? Versus the compelled party was a signatory in the Tuscany case. And as the court had said in the Tuscany case, it is not at all foreseeable or reasonable that a party who has not chosen to become a signatory to any contract with an arbitration clause might be compelled to arbitrate with anyone. So essentially saying it's not foreseeable that we, Western, would know we have to do arbitration if that wasn't included in our insurance policy contract with SecureTrade, right? We didn't know anything about the brokerage agreement. We weren't a signatory. It's not the same as the Tuscany case. Now, this was the first issue you should have dealt with. Any questions about this one before we move on to the next issue? So the next issue is the BAA and the insurance policy agreement are not intertwined, because Secure Trade is saying that the BAA, it was entered into with Secure Trade, but we would have not ever gotten this insurance policy with Secure Trade if there was no brokerage agreement with Assurance. So they're saying these are all intertwined, they're related to each other. Now in our letter, we want to reply, well, here's the rule. A signatory may compel a signatory, a non-signatory may compel a signatory to arbitrate under the Columbia Arbitration Act via equitable estoppel when the signatory raises claims against a non-signatory that are intertwined with the contract containing an arbitration clause, i.e. dependent on rights or duties under the contract. And so what we needed to actually analyze is what's considered intertwined is dependent on rights and duties under the contract. That was the key phrases you need to pull out of the library. As for our analysis, you would pull out the purple facts or the relevant facts, which are in purple. The BAA is a contract for brokerage services to obtain an insurance policy and review consumer claims prior to approval or rejection. That's the first contract. The second contract we're dealing with is the insurance policy, which is a policy for Secure Trade's extended warranties with consumers. A is suing for breach of contract for failure to give A timely and accurate reports and consumer claims under the BAA, the first contract, the brokerage agreement. And W is suing Secure Trade for fraud, so a different cause of action, because Secure Trade stated that 17,000 consumers had presented valid product claims that totaled 36 million, and W paid this. In reality, Secure Trade didn't really know if they were valid or not. And all these facts needed to show up somewhere in your analysis, right? If you did one fact and then explained it, or did all the facts and then explained it later, it's fine. But to summarize it, you just needed to say, well, we have BAA, breach of contract, insurance policy, which is fraud. Although both of these contracts deal with consumer claims, right? That's our little counter argument. It deals with consumer claims, which is why Secure Trade is saying it could be intertwined. The claims themselves are different. Like I said, fraud is one claim, and then fraud is one claim that W is suing for, but then Assurance is suing under breach of contract. And here, IP doesn't rely on the BAA contract in any way, right? The insurance policy contract is completely separate from the BAA. The fact that A is suing for breach of contract, it's dealing with different rights and duties, right? The duties under the BAA are claims of reports, not dealing with the insurance policies that W actually has to pay for. So there's no way they're intertwined. They're different clauses, they're different services. Yes, they got a referral, but we're not going to have any way to cause Western to go to arbitration under this theory of intertwinement. Now that would have been the comparison of the facts with no case analogies, kind of like what you do on an essay. But because we're in PT land, we want to kind of do a case comparison, right? You're always looking for case comparisons when appropriate. And in the Tuscany case, the rights and duties of all the parties, signatories and non-signatories, arose out of one contract, which was the purchase and sales contract. This is different, again, because IP and A are suing under, W is suing under the insurance policy, and Assurance is suing under the brokerage agreement. They have different rights and duties, as we just explained in the previous slide with all these facts of what's actually going on, right? And again, however you use the facts, how you explained it, it didn't really matter as long as you got everything in there in some way that made sense. Questions about number 2 and what you were supposed to do for the second section? All right, so let's go ahead and go to the third section of what you should have done for this PT. And so we have Secure Trade's argument. We're getting all this from the letter that Secure Trade had written. And Secure Trade said, W obtained a direct benefit from Secure Trade, a signatory of the BAA that has an arbitration clause, by obtaining the premium from Secure Trade through the insurance policy, right? And the premium is what they're paying under the insurance policy. And because W and A are affiliates, they have a pre-existing relationship. That's the argument they're trying to say, which says, okay, because we got a direct benefit, we're going to be compelled to arbitrate. Now, our response will cite the rule about, well, what is a direct benefit? We have to define what direct benefit is. And from the case, Tuscany case, it said a signatory may compel another non-signatory to arbitrate only when the other non-signatory has sought and obtained a direct benefit from the contract containing the arbitration clause. That is to say, only when the non-signatory attempts to recover or actually recovers for a breach of contract as a third-party beneficiary. Now, the case gets a little bit more complicated law-wise here compared to the last two issues that were pretty straightforward law-wise, but were kind of confusing fact-wise. This one required you to understand there were two approaches. The approaches other courts take, which is the pre-existing relationship approach, and then the approach that Columbia takes. So other courts say there was essentially a direct benefit under the contract if the person getting the benefit had a pre-existing relationship with one of the signatories. Now in Columbia, they don't really care what the factually or legal related relationship is between the signatories. It determines whether there was a direct benefit based on what the signatory has done, right? Effectively suing on the contract rather. So basically what the signatory did under the contract, what those rights are, not really who they may be. So it's looking at what was done, not who they are or what relationship they had, the actual conduct or result that came out of these contracts. As for the analysis, all the facts were the same from the issue that we had before. So the second issue about them being intertwined, the facts are the same, different contracts, what happened, what the services were, what the terms were. But our inferences will be different. So the red will be different because W is not a beneficiary under the BAA because it has no rights under the BAA. So you can see where stating facts sometimes isn't enough. You have to explain why those facts are important in a PT. And even in an essay, you can have facts applied to multiple issues, but how those facts are interpreted and are supporting an argument under a standard of law depends on the situation. And so here we're talking about the beneficiary direct benefit. We could also argue W is not suing under the BAA, it's suing under the insurance policy. We admit, yes, it received premiums. That's our the counter argument, admitting that's something that happened, but those were paid under the insurance policy. It wasn't paid under the BAA. And even though W and A are affiliates and have a relationship, it doesn't give W any benefit under the BAA contract, essentially, right? You could say a counter that technically there was a benefit because the brokerage agreement was to get W as, I guess, the person who supplied the insurance policy, but it's still going to be weak because the pre-existing relationship rule is dicta. It was used by other courts. The Columbia courts, which is the area we're in, looks at what the non-signatory has done. And so here W is suing under the insurance policy, not the BAA. It doesn't matter that W is an affiliate of A. But again, this is where you could have had more counter arguments. I think this was probably the most complicated issue out of the three you had to deal with. So if you struggled with this one a little bit, it's no problem. And now that we've done, here are the facts, here's our interpretation of it based on the law. Can we do a case comparison? And yes, we could. Under Tuscany, the rights and duties of all parties arose out of one contract. And here, W is suing under the insurance policy and A is suing under the BAA. And there's different rights and duties. W is not a party to the BAA and there's no benefits under it, right? Similar to our argument that we made for the second issue. Any questions about this third one? Okay. So once you've written these three sections, you have to have a short conclusion just to make your work look complete. And you just kind of put what your main points are. The motion to compel will be denied because W is not a signatory, Ks are not intertwined, and W received no direct benefit under the BAA. You don't have to make the conclusion long. Don't spend a lot of time on it. You don't get a ton of points for it. It just has to be there. Essentially, it's your headings that you just put in paragraph form, and then you move on so you can use that time to do a lot of the case comparisons or analysis. Now, this is what you should have done. Hopefully gotten most of it. If you didn't, no problem. We'll talk about what you do after when you finished a PT to make sure that you improve and get better at PTs because PTs are worth 2 essays. They're equivalent to 2 essays. So you definitely want to get a good score on the